The Hartwell Circuit Appellate Courthouse opened its doors at 8 o'clock on a Tuesday morning, and by half past the hour the marble corridor outside Courtroom 4 was already moving with the particular quiet urgency of people who understood that a judge's time was not a negotiable resource. Celeste Acaffer arrived at 8:34. She carried a leather document bag over one shoulder, a travel mug in her left hand, and the kind of composure that does not announce itself. She wore a charcoal blazer over a pressed white blouse, her credentials lanyard tucked inside her collar, her name, Celeste Acaffer, lead appellate counsel, Hargrove and Sellin LLP, printed on the badge she had not yet pulled out because she had not yet needed to. She did not look uncertain. She did not look like someone unsure of where she was going. She walked the corridor the way people walk corridors they have walked 100 times before, because she had. Marisol Vega, 3 weeks into her first clerkship with the Honorable Chief Justice Adeline Prout of the Hartwell Circuit, was standing inside the heavy oak doors of Courtroom 4 when Celeste Acaffer reached them. Marisol had propped one door open 2 inches to let air move through the gallery while the bench officer finished arranging the case folders. She was not meant to be watching the corridor, but the corridor was right there, and Marisol was 24 and still learning which details mattered, so she watched. She watched Senior Bailiff Trent step into the path of the woman in the charcoal blazer. Gerald Trent had worked the 3rd floor of the Hartwell Circuit Courthouse for 15 years. He was not a cruel man. He was, by his own accounting, a careful one. He prided himself on reading a room and on reading the people who approached it. He could tell, he often said, within 10 seconds whether someone belonged. He had made his decision before Celeste Acaffer reached the doors. "Galleries at capacity," he said. "Priority seating this morning is reserved for parties withstanding in the matter. You'll need to wait in the hall." Marisol watched the woman stop. Not flinch, stop. There is a difference, and Marisol would spend a long time afterward thinking about it. A flinch is surprise. A stop is a person deciding, in the space of one breath, how to respond to something they have encountered before. "I'm not here for the gallery," Celeste Acaffer said. Her voice was level. Not loud, not soft level, the way a well-calibrated instrument is level. "My name is Celeste Acaffer. I'm lead appellate counsel on the Brannigan matter. That's the case on the docket this morning." Bailiff Trent did not step aside. "The attorney tables are already set," he said. "Counsel for both parties checked in at the clerk's window downstairs. If you need to check in, that's the place to do it." "I checked in downstairs at 8:15, she said. "My entry is in the log." "Then you'll be called in when the session opens." He gestured toward the bench along the far corridor wall. "If you'll wait over there." Marisol held very still behind the 2-inch gap in the door. Celeste Acaffer looked at the bailiff for a moment, not with anger, with clarity. Then she said, quietly and without heat, "I want you to be aware that I have identified myself as counsel of record and that I am being directed to wait in the hallway. I'm nodding the time. It is 8:36. She walked to the bench along the wall and sat down, her document bag across her knees, her travel mug resting beside her, her posture exactly as it had been when she came off the elevator. She did not take out her phone. She did not pace. She waited the way someone waits when they know with complete certainty that the waiting will be short. Bailiff Trent turned back to the doors and straightened his jacket. Inside Courtroom 4, the gallery filled with the low shuffle of observers finding seats, journalists, a handful of law students, 2 rows of spectators who had followed the Brannigan appeal in the papers. At 9 o'clock precisely, the door behind the bench opened, and Chief Justice Adeline Prout entered. The room rose. Justice Prout was 63 years old, with close-cropped silver hair and the kind of stillness that courtrooms generate in people who have sat in judgment long enough to know what they are looking for. She had presided over the Hartwell Circuit for 11 years. In that time, she had seen nearly everything a courthouse corridor could produce. She had very little patience for wasted time, and no patience at all for wasted time that did not need to be wasted. The room sat. Her clerk, not Marisol, but the senior clerk, Daniel, who managed the session calendar, read the first matter. Brannigan Properties versus the Meridian Land Trust, case number HC2241. Appellants are represented by counsel. Respondent's lead counsel is, he stopped. He looked at the appellant's table. He looked at Justice Prout. Respondent's lead counsel is Celeste Acaffer of Hargrove and Selin. I do not see Ms. Acaffer at the table. Justice Prout looked at the table. Then she looked at Marisol, who was standing to the left of the bench with her notepad and her 3 weeks of experience, and the particular expression of someone who knows something she has not yet been asked. Ms. Vega, Justice Prout said, is there something you'd like to tell me? Marisol had not planned to speak. She was a clerk. Clerks did not interrupt sessions. But Justice Prout was looking at her directly, and the question had been asked, and the answer was sitting on a bench in the corridor. I think she may be in the hall, Your Honor, Marisol said. I saw Bailiff Trent turn someone away from the doors before the session opened. The woman said she was lead counsel on this matter. He directed her to wait outside. The courtroom was very quiet. Justice Prout did not raise her voice. She did not alter her expression. She said, Please go and bring Ms. Acaffer in. Marisol went. She pushed through the oak doors and into the corridor. Celeste Acaffer was exactly where she had been, on the bench against the wall, document bag across her knees, posture unchanged, as though she had simply paused in the middle of an ordinary morning and was waiting for it to resume. Ms. Acaffer, Marisol said, Chief Justice Prout would like you to come in. I'm sorry. I saw what happened and I should have said something sooner. Celeste Acaffer stood. She adjusted the strap of her document bag. She looked at Marisol with a calm that was not distant. It was, Marisol would think later, almost kind. The kindness of someone who understands that the young clerk at the door is not the problem and who knows the difference. You said something when it counted, she said. That's not nothing. She walked back through the oak doors and into courtroom 4. The gallery turned as she entered. Bailiff Trent, standing at his post near the side wall, went still. Marisol watched him register what was happening. The attorney he had sent to the corridor was now walking to the respondent's table, setting down her bag, being acknowledged by Chief Justice Prout with a nod, and she watched the color shift in his face as the arithmetic of the morning completed itself. Ms. Acaffer, Justice Prout said, the court is glad you're here. We'll proceed. The session ran for 2 hours and 20 minutes. Celeste Acaffer argued her portion of the appeal with the same composure she had carried into the courthouse that morning, clear, precise, unhurried, certain. She did not glance at Bailiff Trent. She did not reference the corridor. She was in a courtroom and she was doing her work. When the session closed and the gallery emptied, Justice Prout remained at the bench for a moment with Daniel, the senior clerk. Marisol heard only part of what was said. She heard the words court administrator and formal note and this morning's incident at the doors. She heard Justice Prout's voice, still level, still without theater, say, I want it in the administrative record, and I want the administrator to open a review today. She did not hear the rest because she went out to collect the session files from the clerk's table, but she heard enough. By mid-afternoon, the court administrator's office had been in contact with the supervisor overseeing third-floor court security. Senior Bailiff Trent was formally reassigned, removed from courtroom duty pending the outcome of the administrative review, and a notice was placed in his personnel file. The review would determine whether his action constituted a violation of the court's access and conduct protocols, and it would require him to complete court access and professional conduct training before any return to gallery door duties was considered. That process was not dramatic. It did not happen in front of an audience. It happened in the administrator's office, in the language of policy and procedure, in the way that institutional accountability actually works when the institution takes it seriously. The written apology, signed by the security supervisor on behalf of the third-floor court security unit, addressed to Celeste Okafor, was delivered to Hargrove and Sellon LLP by end of business. It was formal and unambiguous, and it placed the acknowledgement of error on the record. Marisol Vega learned about all of this the following morning, when Daniel passed the details along during the daily briefing. She listened. She wrote it down. She had come into the clerkship thinking about cases, about the arguments, the legal theory, the standards of review, the texture of appellate reasoning. She had spent 3 weeks reading briefs and indexing records and learning the rhythms of chambers. She had thought of the courthouse as a place of ideas. She still thought that, but she thought something else now, too. She thought about a woman in a charcoal blazer sitting on a corridor bench with her document bag across her knees, nodding the time out loud, not as a threat, not as a performance, but as a record. A quiet insistence that what was happening was real, that it was visible, that it would not simply dissolve into the ordinary morning as though it had never occurred. And she thought about the way the justice system, when it is working the way it is supposed to work, does not require that woman to shout or to break or to beg. It requires her to be present, to be correct, to wait briefly while the machinery of accountability does what it exists to do. She had come to the Hartwell Circuit to learn about the law. On a Tuesday morning, in a marble corridor outside courtroom 4, she had learned what it is for.